Nazar Mohammed were both arrested and placed before the courts following an extradition request from the United States of America, an event-packed day. Joining me in studio to break down all that transpired today and all that led up to today's events is none other than the Attorney General and Minister of Legal Affairs, the Honorable Mohabir Anil Nandlall. Minister Nandlall, thank you so much for joining us.
It's a pleasure to be here. Thank you.
Let's start from the beginning. Azruddin and Nazar Mohammed were both sanctioned and subsequently indicted. And there has been an extradition request, I'm told. But Guyanese may not properly understand what exactly that extradition request really entails. Can you explain that to us?
Well, Shakwan, thank you very much for giving me the opportunity to speak on this matter, because I've observed in the social media in particular that there are volumes and volumes of misinformation, inaccurate information, political propaganda, and all sorts of misleading outpourings on this issue. So let's begin with what is an extradition. An extradition is an arrangement that exists and that has existed among civilized nations for over 200 years. It is a political process as well as a legal process. It is a framework, essentially, through which governments request the presence of persons in another country for the purpose of trying those persons in the requesting countries for offenses allegedly committed in the requesting country. It's as simple as that. Over the years, treaties have been executed to put this arrangement in place between and among nations. Statutory processes have been established in individual countries to regulate and govern how this process must unfold. These statutory processes are in place to ensure that there is due process and that the basic rules which govern extradition are observed. So, enshrined in these statutory processes is facilities to ensure that the subject persons are afforded due process, that they can only be subject of a successful extradition if there is evidence sufficient enough for them to stand trial in that foreign land for the offense for which they are accused. That a judicial officer, legally trained and sufficiently independent, examines this evidence and makes a legal determination of that evidential threshold. The process is triggered by a request from the government who is requesting the extradition to be sent to the appropriate authority in the requested state, and that triggers the process. The authority comes from a government to a government, and then the statutory processes as enshrined in the laws are then activated, and that's how the judiciary becomes involved. And this is not uncommon. Almost every civilized country in the free, modern, and democratic world has the framework to which I am referring. And there are treaties between and among nations that establish this framework along with accompanying legislation in all these countries. So Guyana, for example, has had extradition on its statute books since 1883. Of course, we were British Guyana then. We are governed by a treaty on extradition that was executed between Great Britain and the United States in relation to extradition between Britain and the United States. That treaty was executed since 1931. When we became independent in May 1966, Guyana, as a sovereign nation, inherited that treaty as part of our international obligations.
Okay.
In 1988, under the then PNC government, the current Fugitive Offenders Act was enacted, and it repealed the law that was in force at the time. In 2009, this Fugitive Offenders Act was first amended, and then in 2024, it was amended a second time. From independence to now, the Cooperative Republic of Guyana would have done dozens of extraditions. A majority of them were never contested, so you don't even know. Some of them were contested, and there are reported cases on them in law reports of Guyana and law reports in the West Indies. Our extradition framework is no different from that which exists in our sister CARICOM territories and the rest of the British Commonwealth. This year alone, we have extradited 3 or 4 persons already. 2 to North America, 1 to the US, and I think 1 to Canada. But the person surrendered, and there's a facility under the extradition framework.
Yeah.
So there was no necessity to go to court, right? So all this hullabaloo about political persecution, which I'll get into later,
Yeah, right.
and this is something to get the Mohameds, are all part of a narrative that is constructed to be self-serving and politically expedient and convenient to those who wish to put that narrative out there. This extradition, this particular extradition process cannot objectively be surprising to anyone. The investigations into this matter started some 15 years ago. The indictment themselves, or the indictments themselves, speak to periods relating to transactions that began since 2017, long before the PPP was in government. And it ends at a period sometime in 2024. So you're speaking about a transaction period of 7 years. During that time, 2 governments changed in the United States. You had a governmental change in Guyana. So this particular extradition process transcends different governments in both the US and in Guyana. The first indication of these proceedings in being and in process would have been concretely realized when the OFAC sanctions were imposed. Any sensible person would have detected that those sanctions were not imposed in isolation, but were part of a process. And the other aspects of the process will be unfolding later. They are now being unfolded.
AG, I want to ask you about a particular thing, and just to step back a little bit to what you said about political persecution, as we have heard over the last few hours. The main question I think that is circulating in the public domain is the timing in which this arrest was done, one business day before Parliament convenes. Was that intentional on your government's behalf?
The government of Guyana has no control whatsoever in relation to when an extradition request will be made to it. In this case, the extradition request came from the government of the United States of America. We don't control the workings of the United States government. And the Mohameds know full well that this was coming. They knew that it was supposed to come earlier, but the American government thought that they shouldn't do it during the election period. Then the US government was met with a strike that affected some important agencies in the federal apparatus of the US government. And that accounted for some delay. And I'm saying this to you, I'm saying this publicly because the Mohameds are aware of all this, all these workings. So we have no control and had no control in relation to when this request would have been received, would have been made and received by us. The request came in from the United States government yesterday, the 31st of October, under the hand of the Secretary of State of the United States, Mr. Marco Rubio, and under the hand of the Department of Justice. Those are the authorized agencies in the United States government in relation to extradition.
So yes.
For anyone to think that the government of Guyana can influence such high-placed authorities in the US government in terms of extradition or any process, you have to be of fanciful thinking.
Yeah, well, AG, on that particular point, there has been that commentary, particularly from the Mohameds themselves outside of the magistrates court earlier today, that the People's Progressive Party civic government is directly responsible for the political persecution that they're facing. What do you say to that?
I don't know what political persecution they're referring to. They have been indicted by a court of law in southern Florida in a fraud of over 50 billion US dollars. And the American government is requesting their presence in the jurisdiction of the United States of America to answer those charges. Where is the politics in that? The government of Guyana is duty bound under its treaty obligations and under international law to accede to requests for extradition. And we have stated openly that we will discharge those obligations faithfully and in accordance with law and in a manner that ensures that there is due process and the recognition of the constitutional rights of any Guyanese implicated. And that has been the position of successive governments of Guyana. And that is a international obligation of a reciprocal nature that governments operating in the international framework owe each other and discharge in relation to each other as a matter of comity of nations. That's international diplomacy. That's international law. That's international cooperation at work. That is how the world operates. As there are certain officers within the state of Guyana who are ascribed specific responsibilities under the Extradition Framework and the Fugitive Offenders Act. The process begins with the receipt of the documents, including the request, at the Ministry of Foreign Affairs. It is then transmitted to the Minister of Home Affairs. The Attorney General, who is the principal legal advisor of the government of Guyana, and the most senior legal officer of the state of Guyana, is then activated to advise the government of Guyana on the way forward. And the government of Guyana very early committed to this process in keeping with our existing relationship with many countries in the world of cooperation, rendering and extending mutual assistance in criminal matters. And those countries include the United States of America. So there was nothing out of the ordinary. There was nothing extraordinary that was done by the government of Guyana in relation to this process. It has nothing to do with politics. We said openly that whether the request comes or it doesn't come, or if it comes and the gentleman is in the parliament, his presence in the parliament or his status as a member of parliament does not insulate him or immunize him from legal liability of a criminal kind in relation to the extradition process. So whether the request would have come next week, next month, his status would not have changed. It came a few days before and he was granted bail. Now, if the government of Guyana was politically motivated, and if we were driving the process politically, seriously, do you think that bail would have been granted? And bail would have been granted in the sum of $150,000? Isn't that argument being advanced lack common sense on the mere facts that are unfolding before you? What you are seeing there is evidence of non-political interference and an independent judiciary at work.
Yeah. Yesterday, October 30, the request was received. Let's turn our attention to some of the comments made by the defense attorney for the Mohameds, Sion Dojan. He said, first of all, that he is of the legal opinion that these offenses are not extraditable in nature, or not extraditable offenses, and as a result, the Mohameds will not be going anywhere. What do you think?
Lawyers get paid to represent their clients' interests. And I am a lawyer, and I understand that. So, the lawyers who are appearing for the Mohameds, obviously are handsomely paid. I don't think anybody can speculate about the Mohameds' ability to pay handsomely for services. So you're going to get genuine and ingenious arguments from the lawyers, because they are going to be adequately lubricated. And any machine, as you know, that is well oiled and lubricated will work over time. So you will get many more of these arguments being generated. The fact of the matter is, and that is why I began where I began, extradition is not new in the world, and it is not new in Guyana. almost all the arguments that are being advanced have been raised already in Guyana and adjudicated upon conclusively by courts in Guyana. If not Guyana, they have been raised around the world. They have been raised in the Caribbean, they have been raised in the British Commonwealth, and adjudicated upon by highest courts in the judicial hierarchy in those territories. And they form a doctrine of precedent that courts in Guyana can follow as persuasive authorities. We have binding authorities from our Court of Appeal too that will bind the magistrate court in these matters. So that's the first thing. Extradition law is predicated upon a concept called duality and reciprocity. Simply put, what that means is that the offense for which the person is being extradited must be an offense that exists in both countries. In the country that the person is being extradited from, as well as the country, of course, that he's being extradited to. As I said, these requests, these indictments were prepared in the United States of America. We had no role and we played no part in the preparation of these documents. They were prepared by the U.S. Attorney Office and the Department of Justice. I would not want to think that those offices are affected by such high level of incompetence that in the preparation of the charges, they did not study the laws of Guyana to ensure that that duality and reciprocal requirement is not satisfied or is satisfied. Obviously, as I said this, in the preparation of this matter began since 2010. This is not yesterday work, right? And I will not assume that those high offices in the United States justice system and legal system are afflicted with such incompetence and inefficiency that Mr. Marco Rubio is going to put his signature on a document and the Attorney General would advise him to do so without checking the most elementary issue of extradition law. That is to say, that the offense that you're charging them with in America does not exist in Guyana. That is what that argument of Mr. Durjan is asking me to believe. And I can't believe that. But quite apart from that, we have a duty also in Guyana. Before I advise the Minister of Home Affairs to issue what is called an instruction to proceed, I also and other legal authorities in Guyana had to scrutinize the documents to ensure that that requirement is satisfied.
But I'm told this authority to proceed AG was not signed. We're
going to deal with that. Mm-hmm. We have 3 lawyers who are from Jamaica. Jamaica is a country that has many extraditions, has had many extraditions, successful extraditions. An entire gang, the Dudos gang, was extradited out of Jamaica not so long ago. These lawyers who we retained were deputy directors of public prosecutions in Jamaica. They dealt with many extradition requests and extradition proceedings before. They also advised on this matter. If we are being accused of being political again, we could have put PPP lawyers or lawyers that are sympathetic to the PPP to be part of this case. We brought in foreign lawyers in order to ensure that we get diligent and competent service, and that the matter is not perceived to be politically influenced or driven. So those lawyers would have expressed an opinion. What the lay public must understand is that duality, that dual requirement and that reciprocal requirement doesn't mean that the identical offense must exist in the two countries. Similar offenses would suffice, would meet the requirements. And we have had that issue determined. We had drugs cases, for example, where the person was wanted in the US for a particular type of offenses under a Dangerous Drugs Act of the United States. We don't have a Dangerous Drugs Act in Guyana, but we have a Narcotics Psychotropic Substances Act. And the offenses are not identical, but they are similar. And that issue was raised, and our Court of Appeal dealt with that matter. And these lawyers ought to know these authorities. But as I said, they have to earn their pay. So they're going to put out many of these arguments. We have fraud in various species on our statute books from time immemorial. Many of these offenses are species of fraud. We have an anti-money laundering act that creates dozens of offenses. Some of these offenses are relating to anti-money laundering. So I'm not worried about that duality requirement. I believe that the Americans would not have been that careless, reckless, negligent, and inefficient in not satisfying themselves that these offenses have the required similarity. And then we examined them ourselves. And we had the input from an expert team from Jamaica. What are the other arguments you raised?
So, Royce, Ford also said that there was an authority to proceed, as you pointed out, but he said that this document was not signed.
Well, I don't know what Mr. Roysdale Ford is referring to, but the authority to proceed was signed by the Minister of Home Affairs, who is the statutory authorized signatory to that document. It was prepared. I heard them say that it was defective. Well, the Fugitive Offenders Act has forms in the schedule of the Act. And these forms contain precedents or specimens of what these documents ought to look like. And over the years, these are the forms that have been used. And obviously, not only did we look at past such documents, but we corresponded them with the form that is in the law. And they coincide. We're going to be that reckless to have an unsigned document presented to a magistrate? Or there is a form at the back of the law and you're going to ignore the law? That's what I'm saying. It's a payday.
Let's touch on one more thing said by Mr. Azzuddin Mohamed in his commentary just outside of the magistrate's court earlier today. He said that there are a number of government officials who may have been complicit in the acts that he's being alleged to have committed. But government has already said, AG, that condign measures will be taken against any official who has been involved in this. Why do you think that statement keeps coming up?
Well, you know what the allegation is? The allegation in the indictment and in the other supporting documents and in the OFAC sanction is that the Mohameds bribed government officials. So I don't understand how the Mohammeds can be mystified about who the government officials are. If I bribe you, I must know who you are. Why don't they list or name the government officials whom they bribed? It's as simple as that. They are the best person to answer that question rather than pose it aloud for others to speculate and to try to create political propaganda. But I want to get back to some more of the legal arguments because the lay public there is running away with all kind of impressions because of what is being peddled. And they're hearing one side only. Another argument advanced is that something is unconstitutional. And I am not, it is sexy to allege unconstitutionality. People do it all the time. Sometimes it doesn't even involve the Constitution. So they have not said, when you say something is unconstitutional, you first have to identify a provision of the Constitution that is being breached and then say how it is being breached. That is what makes something unconstitutional. I may have missed it, but I have not heard a contention in or out of the court that alleges the breach of a specific provision of the Constitution or a set of provisions of the Constitution. So I don't know where the unconstitutionality is. But they advanced an argument, I'm told, in the course of the proceedings of unconstitutionality. And then they invoked a provision in the Constitution that says that if constitutional issues are raised in criminal proceedings before the magistrate, then the person who is making these allegations, these constitutional infraction allegations, must invite the magistrate either to rule on it or to refer it to the High Court for determination. They didn't do that. That is a process and a procedure that is available to them. They could have done that today. They did not do that today. But they make these allegations and contentions of unconstitutionality. Because to the lay person, and perhaps to the Mohameds, it sounds attractive. And perhaps paves the way for greater lubrication. So that's how I'll answer that question.
As we wrap up our conversation, AG, when we look at the fact that this matter has now been adjourned to November 10, where does the state, its representative attorneys, and this matter, where do we go from here?
Sorry, repeat that. I just was distracted.
That's all right.
Yes.
Where do we move from here? After this case has been heard today, we know that it's been adjourned to November 10. What's the next step?
Well, the next step is for us to the state to disclose to the defense the paperwork that was received from the United States, and for them to prepare themselves for the hearing. Now, the public must also understand the nature of the hearing, the nature of these proceedings. It is akin to committal proceedings, like a preliminary inquiry, which we just abolished. This is not a trial. The trial will take place in the United States of America. This magistrate needs to be satisfied that based upon the evidence provided, that there is sufficient materials and sufficient evidence to commit these people to stand trial in the United States, in the same way that a magistrate would have conducted an inquiry to determine whether a person should stand trial before a judge and jury. So it's not a very high threshold. And you don't have to lead all the evidence. It's a sufficiency test. Once you're able to establish what is called a prima facie case, then a magistrate ought to commit to stand trial. When that process is completed, the file goes back to the Home Affairs Minister. Remember, this process is triggered by an authority to proceed by the Home Affairs Minister. Once it goes back to the Home Affairs Minister, it goes back there with a committal order or a discharge order, meaning the accused are discharged or they are committed to be extradited. And then the decision is made to extradite.
AG, I want to thank you so much for sharing those comments with us before we wrap up. Of course, any final commentary from you as we close?
No, I just want the public to appreciate that this is a legal process, and I hope that I have clarified a lot of issues, and that there is a deliberate attempt to politicize what is clearly a non-political process, and that there is no ulterior motive, at least on the part of the government of Guyana, in relation to this process. It is what we are duty-bound to do under law and what we are committed to do. And importantly, I am told that during the course of next week, we will get some more extradition requests. Perhaps the Mohameds will feel a little better when that is made public. And we will make that public once we receive them, the same way that we have made the Mohamed extradition request public.
AG, thank you so much for spending the last few minutes here in studio with us. You've heard there from the Honorable Attorney General and Minister of Legal Affairs on very pressing matters of national importance. Thank you so much for tuning in to the National Communications Network. My name is Shaquan Gill, and I'm saying goodbye for now.